The first part of the afternoon has to do with some very important principles of custody and access. And as you know, the Supreme Court of Canada has recently dealt with this subject matter in terms of the right to give children religious instruction and the resulting conflict over parental rights and the best interests of the children. That has a lot of other things to say about custody, and our presenters this afternoon, although they both know of the case, are not necessarily going to dwell on that. But we do have a different approach that seems to be emerging to the resolution of custody questions, and some of the reasons why that new approach is necessary will be explained by our first speaker, who is a social worker well known to many of us. And as before, I'm going to follow the procedure of not making lengthy introductions, because you do have the biographic material in your books, and you will, I'm sure, be glancing at those entries. And I don't want to take time from the speaker. So I think we have enough of you gathered now to begin, and it's my pleasure at this time to call on Mr. Robert L. McWhinney to talk to us about the winner-loser syndrome.
Thank you, Mr. Chair. Ladies and gentlemen, I think perhaps the most significant thing about this particular presentation is in its timing, right after lunch. We all know what right after lunch is for. It's time for a little snooze. And so I think that your chair quite purposely arranged for a speaker whose voice would be perhaps sufficiently bass and mellow as to facilitate with a proper droning quality the necessary sleep. I thought actually that Jim's voice would have been just fine, but probably some of you have been, as students, have been imprinted in the first word and you'd have been out like a light, and I don't think we want anything that obvious. I actually suggested Jim may just make a long introduction to the next speaker, but he told me that some of you might suffer early afternoon insomnia, and that I should provide some remarks just to keep you amused while the rest were sleeping. But he also said that this presentation was really an introduction, a kind of preamble to the more important paper to follow on where custody assessments are going in the future. It's not that my paper is irrelevant or unimportant. It's not really that at all, I'm sure. Simply that my job is to help nature at this point, and I intend to do so. I would, however, ask those of you who are unfortunate enough to be unable to sleep if you would clap loudly when I finish. This will alert the others that it's time to wake up for the next presentation, and it will give me some sense of satisfaction that I've done something that I was intended to do here. The gist of my presentation is really to give some of the historical antecedents to the current predicament of custody determination. And it will, in fact, be a preamble to my colleague, Mr. Robert Tompkins' remarks, which will follow next. I'd like to begin by remarking that I do believe that there is fashion in custody determination, and that the danger that we incur is in believing that the last word is really the final word and the truth. I think, moreover, that fashion in custody determination is changing more rapidly. It took centuries to move from one principle to the next, decades after that, and I think now we're moving to a turnover of fundamental ideas in just a matter of years. The basic criterion of child custody determination, as you all know, has been based on radically different principles over the years. The principle that the father, as a man, had a rightful claim to the custody of his child, as he did to other property. The tender years doctrine, in which the development of the child was viewed as fundamentally related to the emotional relationship between the child and his or her mother. And now the current fashion, the best interests of the child, has become the defining criterion. In family law, then, the principle, I must be speaking too loudly, I don't see enough nodding heads here, has moved from the principle of the child being the physical property of the father to the psychological property of the mother, and now that the child is a legal entity in his or her own right. And I think, in fairness, it's probably reasonable to assume that each of these principles has been the best or the most suitable principle in its time, given the received opinion of the day, psychologically, legally, and socially. And just as the criterion of custody determination has shifted, so too has the manner of ascertaining a child's best interests. You'll remember that less than even a quarter of a century ago, typically assessments were conducted by a psychiatrist who was retained by one or other of the parents. And the resulting recommendations, not surprisingly, tended to support the claim of the parent who had retained the psychiatrist. I don't think this is only because of who was paying the psychiatrist's fee. I think more significantly, the problem was that the assessor had access only to one parent and to the child, and therefore the parent-child relationship. The inadequacy of such one-sided assessments, which are necessarily partial and therefore lend themselves to being adversarial, was evident for years, but it required the advent of a new kind of thinking in order to enable the shift to occur, which both I and Bob Tompkins will be speaking about, a shift that took custody assessment, custody determination into an entirely new realm. This new thinking emerged from the application of systems theory to psychotherapy. And the result was that mental or emotional problems were now seen not as intrapsychic, that is, arising and existing only in the psyche of individuals, but in the interaction between and amongst psyches, or in the interpersonal relationships. One of the consequences of this was a paradigm shift that took place in the mental health field, which has had an impact on custody determination, which is why I'm raising it today. The whole notion of what constituted mental dysfunction, its etiology, its reality, and significantly its treatment, was changed as a result of this shift. Styles of intervention were necessarily changed because the phenomena that were being dealt with were no longer the unconscious phenomena of the psyche, but the much more evident phenomena of the interactional realities amongst family members. And of course, a new array of techniques was soon developed in response to the practical needs of this theoretical model. It was largely psychologists, social workers, and to a lesser extent nurses who pioneered and developed this new practice, and the importance of that is that it resulted in a concomitant demedicalization of psychotherapy. Non-medical mental health professionals who had never been really enamored of the medical model but were often wedded to it through their places of work welcomed this change because it enabled them to take a more normal perspective towards their clients. This explosion, for it was really that in the mental health field, had several effects on custody assessments, and I want to mention a few of them. Because the therapists or counselors were now working with entire families, interviewing several people at the same time, something which was unheard of in psychoanalytic practice and in fact unthinkable in psychoanalytic and neo-psychoanalytic theory, these new therapists began to develop skills in intervening in the very current of interactional phenomena which make up family life. And this, of course, rendered them especially relevant in regard to assessing families as a whole and in appreciating the ongoing needs of children in those families. As well, the new systems model demanded of the practitioner a hitherto unconsidered impartiality. And this was significant because impartiality was to become a defining characteristic of the new fashion in neutral custody assessments. Whereas assessments were formerly undertaken, as I mentioned, on behalf of only one parent, now they were taken on behalf of both parents together, or if you like, on behalf of the family as a whole. The old practice of one-sided assessments, in fact, became virtually unethical as they were considered. The idea of the neutral assessor was able to emerge because there were now, in fact, a number of professionals who were able to practice neutrally because of their experience in being impartial in working with families as a group. Now, notwithstanding this fundamental conceptual shift in psychotherapy, no equivalent shift had occurred, at least so far as we knew it, in family law. The law was still driven by its traditional focus on individuals and the rights of individuals, and it could hardly be otherwise. For to speak instead, for example, about the rights of families as a whole would have required a conceptual framework which apparently was not yet available. In family law, we first approached systemic thinking when we removed blame from marital dissolution and moved toward no-fault divorce. The closest we then came to accepting a systemic perspective of the whole family was when we realized that the new fashion of the best interests of the child did not lend itself to an easy or unequivocal definition, and that when it came to operationalizing the concept of the best interests of the child, it was not possible to do so without taking into account the best interests of the family, the best interest of each of the child's parents. The effect of all this was that in regard to custody matters, all of us, lawyers and mental health professionals alike, were necessarily operating, whether we knew it or not, between two paradigms, which explains some of the discomfort most of us feel in dealing with custody matters. The very concept of custody does not bridge these two paradigms. And that is partly because of a lack of congruence between the paradigms themselves, and partly because the psychosocial concept of the best interests of the child does not fit into the legal concept of rights. The concept of custody, the right of the parent to the care and control of the child, cannot contain the concept of best interest. Necessarily, it must reduce best interests of the child, which can only be understood in the larger context of the child's life, to the idea of individual parental rights. What seems to be required is some equivalent to the concept of custody which could address the individual needs of the child within the interactional framework of the family. And a framework which I will mention because Mr. Tompkins will speak about it later in more detail is composed of structures, of schedules, of responsibilities, of competing needs, and of resources, usually scarce resources. It's no accident that there is, in fact, some legislation which takes the requirements of the new fashion in custody determination somewhat into account. And this is what Mr. Tompkins will be examining in more detail. When determinations are made under such legislation, they are not made in the traditional language of the law, but in a different language, a different voice representing a different point of view. Parents, for example, are no longer granted custody and access. Instead, their respective duties and responsibilities are delineated. And the living arrangements for the children are described in what is now being referred to as a parenting plan. I think one might reasonably ask whether these changes that I've just been referring to bring about any real difference. That is to say, essentially, either the mother gets the child or the father gets the child, or they may divide it. But what difference does it actually make to the situation, the experience of the child, and how does it improve, if it does, the child's best interest? It could be argued, for example, that whether one calls it the legal right of the parent to the custody of the child or the responsibility of the parent to meet the needs of the child, surely in a custody dispute it amounts to the same thing. It's true, certainly, that custody is indeed custody from the point of view of parental rights. However, from the newer perspective that I'm speaking to of parental responsibilities, custody is not simply custody. Custody is care rather more than control. It is responsibility, and responsibility is more than possession. The concept of parental responsibility, as distinct from that of parental rights, invites a different attitude, and that attitude in turn generates quite a different response, and I think in there lies the merit of it. One approach incites separateness and hostility, and the other elicits cooperation. The argument for a new change in fashion about what to do with children when their parents separate is not, however, only a conceptual argument. It's also a social and a psychological one. It is one with which most of us are familiar personally as well as professionally. We've all seen the harm that can occur as a result of the more or less winner-takes-all assumption of what we might now refer to as the former or older-fashioned approach to custody disputes. And few of us, though we may laud the adversarial process of the law, rejoice in its effects on families. The terror for parents of a court-ordered custody determination is not the staggering fees, it's not the shame of one private intimacy or indiscretion after another being exposed in affidavits, or the confusing punishment of cross-examination, nor is it the fear of losing custody per se. The real terror is the possibility of losing the right to parent their child, the possibility that ultimately they may lose the relationship with their child, and they fear becoming alienated through that process. This is not to say that the loss of custody itself is of no import at all. There's always the fear that there will only be a winner and no second place in one's own custody suit. The relegation to the inferior status of a non-custodial parent, even without the other parent flaunting his or her victory, the legal diminishment of a person's parenthood, none of these can enhance the feelings or the performance of that parent. And the subsequent bereavement for the loss of a meaningful parental status can affect both the parent and the child. Parents, and I hardly need to explain this, need to feel importantly and meaningfully involved in their child's life. They need to know that they can continue to play an integral role, even though each may define that role very differently. Divorce research shows, for example, that men tend to drift away from and even ultimately to abandon their children if they lose custody and feel deprived of what they consider to be a meaningful role in their children's lives. The majority of children regard the loss of a parent as the single most negative aspect for them of separation and divorce. Children also worry that if their parents can stop loving each other, they could surely stop loving them as well. And parental custody battles seldom persuade a child that he or she is greatly loved. Since many children blame themselves for their parents' separation in the first place, any subsequent custody conflict only compounds their sense of responsibility for that conflict and their fear of losing the love and care of their parents. One of the consequences of the so-called win-lose syndrome is that the custodial parent often becomes, in effect, a single parent, and a parent who is not only the sole legal custodian, but also a perhaps working full-time single parent, can hardly be expected to cope sufficiently on his or her own, especially with pubescent or adolescent children. No culture expects this of its parents. If one adds to this parental burden the general economic impoverishment of separated custodial mothers, the situation is even more dire. Ironically, then, the parent who wins also effectively loses, and the children too. Yet even if a parent might prefer not to have the sole custodial responsibility for his or her child, the risk of losing custody is usually too frightening to contemplate. Consequently, the win-lose model of custody determination sometimes leaves the parent no alternative but to seek sole custody. Even the prospect of a temporary arrangement with the child, for example, living for the time being with the other parent, lies heavily under the shadow of a potentially unalterable status quo. It is this very kind of predicament, however, which helps us to shift the focus from the child to its parents. Parents approach the court on a custody matter only when they have abandoned their own pre-separation approach to child rearing, whatever it may have been, and have given up their joint parental search for the best ways in which to meet their child's needs under the family's changed circumstances. It is only when they have redefined their parental objective to be the adversarial attainment of custody that they go to court. It's not entirely evident as to why this happens. Parents, when they are married and living together, quarrel all the time about how to raise their children. But they seldom make their quarrels public, and they never seek custody. Yet the same parents do just that when they separate. The decision to seek custody sunders the hitherto co-parental, though seldom co-equal, relationship into an adversarial one. And it is this separating of the parents instead of the spouses which I believe has been the fundamental fallacy of custody law. Doubtless there are many and complex reasons for the adversarial parental behavior I've just mentioned. The fact that the law regarding children whose parents are separating is a law of custody probably only exacerbates the problem. In fact, the whole, what we might call family law custody determination complex in providing for such behavior probably invites and reinforces it. Nevertheless, sometimes even quite simple changes can make a significant difference, changes in the language or in the rules, changes in attitude. For example, it could be argued that since a family is a system, and since children need two parents, psychologically as well as biologically, then we should forswear determining custody on the basis of a win-lose model. Because, as I've already indicated, in a family, if one member loses, then all will suffer. And if one parent loses custody, then not only may that parent's relationship with the child be damaged, but the self-esteem of both may be harmed, and to the detriment of all. In order to prevent these maleficent effects, we should ask ourselves the following question. What are the best possible arrangements that both parents can make for their children? Such a question seems innocuous, yet if the test of custody determination is the former question, who is the better parent, then by definition, one parent must win and the other lose. If, however, the question is, what are the best possible parenting arrangements that can be made by both parents for their children, then we are free to move toward a non-adversarial approach to custody dispute resolution, which, except in the most unusual circumstances, both parents can win because each does have something to contribute to his or her child. This shift of operational question, a sort of best interest sleight of hand, if you like, is disarmingly simple. In order to establish the best parenting arrangements, different custody assessment procedures would be required. For example, we would rarely need to conduct a psychiatric mental status examination of the parents in order to arrive at the best plans for a child, for we would no longer be trying to determine who is unfit. Similarly, we would no longer be asking to which parent is the child bonded as though children bonded to only one parent. We would, however, need to define the functions of parenting much more than we have done in the past. We would also need to be more future-oriented, not focused on past behavior, but on present alternatives and future possibilities. Of course, we would also need the language of parenting instead of the language of custody, but this is not a new language. It is, in fact, the same language that parents use when they live together raising their children. It only need to be applied still when they live apart raising their children. Our purposes then as family lawyers, family mediators, assessors, judges would not be merely to settle spousal disputes, but actually to help families in working out their new arrangements. Although parents may come to us in apparent dispute over the custody of their children, they are in reality parents in need of help in assuming the changed responsibilities for their children, responsibilities which require making new parenting arrangements, or more succinctly, a new parenting plan. What is needed from the court, therefore, is not so much a determination of custody, if that be needed at all, as an order supporting the implementation of new parenting arrangements. In this new fashion, it need hardly be said, we would want to emphasize needs and relationships instead of rights and entitlements, and not the simple needs of individuals at law, but the more complex and interacting needs of families in life. Let me conclude by saying that if we were to extrapolate these new-fashioned ideas about custody determination, we would probably arrive at the opinion that although one result of the custody determination process might be the resolution of a dispute, the process should not be regarded as a dispute resolution device per se. Rather, it should be also viewed as a helpful, healing, educational, conciliatory means of enabling families to survive the crisis of their separation and of allowing parents, even within the framework of a custody case, to participate in and contribute to the determination of their own parenting arrangements, that is to say, in formulating their own parenting plan. It might, I suppose, be argued that such ideas are fanciful, unrealistic, entirely beyond the realm of human possibility, or that such an approach toward the resolution of custody disputes represents a fashion which, to put it kindly, is still well ahead of its time. As for the corollary, which would affect you more particularly, that family law itself should become not only less adversarial, but more conciliatory, but even healing, well, such an absurd notion would require a continuing and very dramatic shift in the law, moving beyond the recent shift from a retributive to a more distributive concept of justice and on to a restorative concept of justice. And it may be that we're not quite ready for that yet. Yet the confluence of three disciplines, family law, family therapy, and conflict resolution, has already seen extraordinarily creative developments with which I'm sure many of you are familiar. Not only is there a much greater tolerance for the complexities and ambiguities of family life, but there's a greater energy and enthusiasm for achieving more constructive means of responding to the real needs of separating families. Thank you.
Thank you very much, Bob. We now have another Bob, a visitor from the United States, who is president of a very good association there, and it does have a branch here in Ontario. And any of you who would like to should try to join the Association of Family and Conciliation Courts. We're pleased to have with us now the president of that association and also the deputy director for family services of the Connecticut Superior Court, which is a mental health branch which should be the envy of all of us here. Mr. Robert Tompkins will now talk to us about the parenting plan approach.
Thanks, Jim. Ladies and gentlemen, barristers and solicitors, God, I love that name. So dignified, so civilized, as opposed to our guttural attorneys. It's truly an honor to be here today, to be participating in such a prestigious event, your special lecture series. And I'd like to thank Jim for inviting me in particular, and also congratulate Jim on putting together a wonderful program for you all. Jim mentioned I'm from the States, and by definition, I'm ignorant. Imagine my relief when I found out that I was speaking to the Law Society of Upper Canada and did not have to travel to the Northwest Territories. But instead got to visit your beautiful city. I'm also extremely intimidated. I first found out that I had to follow the always thoughtful and even more eloquent Bob McWhinney. I then looked at the program and found that after our portion of the program was through, the podium was going to be assumed by your distinguished jurists and even 2 Supreme Court justices from your Supreme Court. And then finally, I heard about how you all treated your most recent visitors from the States. The Philadelphia Phillies. Joe Carter isn't in the room, is he? You not only have the last 2 World Series championships, but then 3 days ago I hear you're getting an NBA franchise. Is nothing sacred? Enough already. Bob's remarks reminded me of an event that occurred, or an occurrence that I experienced a couple of years ago. I was in court and ran across a lady that I knew had gone through not only a divorce, but a bitter custody dispute. The case was evaluated, assessed by our office. The case was tried, several days of trial. And she was back in court for something or other, and I just, in passing, said hello to her and asked her how things were going. And she responded very unenthusiastically, something like, all right, not great, something like that. To which I said, well, I don't understand. If I remember correctly, you won your custody case. Her response to me was, yeah, I won all right. I won the right to go to all the parent-teacher conferences. I won the right to get all the phone calls at work regarding the kids when they misbehave or when they're sick. I won the right to take them to all of their activities, day after day, night after night. I won the right to look at the discipline that they need and then carry that discipline out. I won the right to stay home night after night and care for them. If I won, how come I feel like such a loser? I think that's meaningful. It's meaningful both in terms of Bob's remarks, and I think it's meaningful in terms of what I've been asked to talk about, and that's parenting plans. I have to admit that I felt much better, less intimidated, when I learned what the topic was that I was to speak about, parenting plans. An idea that's of great interest to me personally, both philosophically, from a conceptual basis, and also experientially from my past as a mediator and custody assessor. An idea that's being explored in more and more forums throughout North America, throughout the world, wherever judiciaries are meeting, wherever legislative bodies are meeting, wherever law societies are meeting, your own custody and access consultation that is going on here right now. An idea that's become a reality, at least in some jurisdictions. And an idea that I'm convinced we're all going to see that is the future of family law as it pertains to child rearing. Bob did an excellent job of articulating the backdrop from which the concepts of parental responsibility and parenting plans grew. He hinted at the future. My job in this is to try to flush out that future and what that future might look like for us. But before doing that, and before exploring the future, I believe we need to re-examine some of the basic concepts about laws and families and the roles of the individual players in that process. Laws and families are a marriage, an uneasy marriage, a marriage that like many of the marriages that you all encounter in your practices, consists of a dynamic tension. Why does that dynamic tension exist? I believe it exists because families come to a system built on the traditions of law, traditions that involve advocacy and legal rights, systems that are designed to determine right or wrong, guilt or innocence, liability, questions of restitution, questions of equity. And into that system is introduced a concept called best interests of children. Very little to do with the traditions of family law. Families come into that system with a variety of needs. They certainly have legal needs, but they also have emotional needs. They have needs as individuals and collective needs as a family. They have immediate needs, they have long-term needs. They have needs as adults, and they have needs as children. They come in with needs for education and information, both as individuals and as a family unit. They come in with needs for attention, unique individual attention to their unique and individual family situation. Bob alluded to their needs for healing and help adjusting at a time when their families are at their absolute worst. And they come into the legal system with a need for help in reorganizing and for help in giving them the tools to solve future family disputes. Can the courts meet these needs? I don't think so. No wonder judges in family cases have such a hard time. Can the lawyers meet these needs? I don't think so. Even with the enlightened elevation of the practice of family law in recent years. Can the mental health professionals meet these needs alone? No way. That's why you see so much burnout in the mental health profession. However, a system, I believe, can be created that does meet these needs, that utilizes all these players in new and different ways to meet the individual needs of families that are experiencing the need to reorganize. What might that system look like? What if the legislative bodies rethought family law and established a public policy that emphasized parental responsibility over individual rights? What if legislative bodies looked at family law and established a public policy that looked at divorce not as one party suing another party, but as a family event in which one applies for reorganization? You apply for marriage licenses, why not apply to reorganize? How about if legislative bodies and courts and lawyers and mental health professionals banded together to create, support, and provide parent education programs for families to meet their needs for education about what they're going through, what the adults are going through in a divorce, how the kids are affected at different ages, what are the age-specific needs of children, young children, older children, and how parents can meet those needs. And what if all the players got together and, to help families restructure themselves, created a vehicle or a mechanism that required parenting issues receive more attention than they've been receiving now? One of the sad commentaries that I believe on family law is that 90% of the energy, emotional energy, judicial energy, legal energy in family law cases is devoted to the resolution of financial and property issues, and 10% of that energy is devoted to the resolution or the education regarding child-rearing issues. That vehicle, I believe, is the concept of parenting plans, which, with the assistance of lawyers and, when necessary, counselors and mediators and custody assessors, parenting plans that require all of the players, including the families, to pay thoughtful attention to their parenting responsibilities as they pertain to the myriad of parental functions and tasks that we all know exist for parents. As I mentioned, parenting, well, I guess I didn't mention it. Parenting plans, I feel, are the extension, or the current extension. Bob talked about what's fashion now. I believe they're the current extension of the maturation of, or evolution of family law. We've seen fault turn into no fault, sole custody turn into joint custody. We've seen parental rights turn into parental responsibilities, and now we're seeing shared parental responsibilities. In England, a few years ago, they passed legislation that emphasized children's rights and parental responsibility. In the state of Maine, we've seen legislation that talks, instead of custody and visitation, talks about parental rights and responsibilities. In Florida, legislation was passed that, quote, indicates the court shall order parental responsibility be shared in all divorces unless there are special circumstances. And finally, the state of Washington, in which the legislature totally and specifically embraced the concept of parenting plans and took it to the farthest extension that we've seen it yet. In looking at the Washington scheme and what they've done in Washington, I think there's two things that need to be remembered. First, the concept of parenting plans and what's behind the concept. And secondly, what the legislation did operationally to put teeth into the concept. It's also important to look at how they arrived at their legislation. They formed an ad hoc committee that represented all the disciplines. Jim mentioned the association I'm involved with, AFCC. Much like that, got lawyers together, judges, people from the judiciary, the mental health professionals, all the advocacy groups, children's rights, parental rights, women's groups, men's groups, got them together to develop something better than what was happening. They were able to come up with and establish 4 goals for their legislative process, 4 goals for which they were aiming to meet. First, they wanted to encourage parenting arrangements that were reflective of the unique characteristics of each and every family, rather than something that was formalized. They wanted to promote substantial and continued parental participation in post-divorce child rearing. Thirdly, they wanted to help parents focus on children's needs at a time when parents are struggling psychologically with their own survival, and to do that by requiring detailed attention be devoted to post-divorce parenting functions. And lastly, they established the goal of reducing parental conflict by both exposing parental conflict early on in the process, when the family is already in the service delivery system, if you will, and by establishing future dispute resolution mechanisms should problems arise in the future. Let me quickly summarize for you what the parenting plan that Washington has established looks like. If you want, and if you're interested in this subject, I would refer you to an article in the University of Michigan Journal of Law Reform, 1990, the fall edition, volume 24-1, in which looks at this, the Washington scheme in great detail. But just to highlight the scheme for you, to lay out what I believe the future is starting to look like. They did some things operationally in Washington. They mandated the filing of either a proposed parenting plan or a combined agreed parenting plan in all divorces. Initially, the legislation called for that filing of the proposed or the agreed parenting plans to occur along with the filing of the divorce petition or the response. A year later, they changed that. The reasons they changed, and they changed that to requiring that the parenting plan be filed either 30 days before trial or 180 days after the filing of the divorce petition, whichever comes first. And they did that for a couple of reasons. First, they found that parents are at their worst, absolute worst, when they file for the divorce. And they are less able, that's the worst time for them to be focusing on child rearing. And secondly, they found that when proposed parenting plans were filed at the very beginning of the divorce, that it tended to produce polarized positions from which future resolution became difficult. So they changed it to what I described. The second thing they did operationally to give teeth to the concept, to the goals that they were trying to achieve, was to mandate certain levels, details of parenting plan delineation. Thus, they mandated that certain minimal levels of thought be given to post-divorce parenting in specific areas, forcing thought and attention to specific parental functions. Residency. Not only residency and reasonable access, but residency in the specifics, school year residency, summertime residency, school vacation residency, and holidays, birthdays, parents' birthdays, Mother and Father's Day, must be articulated in the parenting plan. Also, transportation, who takes the kids where, when. Decision-making, who has decision-making, in what areas, education, religion, healthcare issues. And then lastly, the parents must decide, as I indicated, what dispute resolution form are we going to go to in the future should we have a problem. Also, from a conceptual basis, and Bob talked about this as well, they eliminated custody and access. Language that, from experience as a mediator who's mediated hundreds of custody and access disputes, how so many of those disputes were not about where the kids were going to live. Those disputes were about wanting to be meaningfully involved in my life, in my children's lives. And so often the words custody and access and the format that the constraints that we had to work in and still have to in Connecticut were without a doubt an impediment to solving the custody and access or the living arrangement problems for these parents. So instead of custody and access, you no longer see those words. You see residential care, you see decision making. I've heard people be concerned about, well, what about kidnapping? How are we going to handle this? There's something in the prescribed form that addresses who the custodial parent shall be in terms of federal or criminal statutes. But it's a very minor spot, and it's only in terms of federal or criminal statutes pertaining to child abduction or kidnapping. And then the law finally also felt that it needed to look after certain groups of people that might be vulnerable. They put protections or limitations into the law so that shared parenting, mutual decision-making, and future conflict resolution forms would be limited if certain circumstances existed. And they articulated those as neglect, willful abandonment, abuse, physical, sexual, or patterns of emotional abuse, and of course, family violence. By now, I think probably everybody or many of you are thinking lofty goals, but cumbersome, or I know a case that this isn't going to work in. No way. Let's take a look at the reality. I described what the plan looks like. How's it shaking out in actual practice? There was only one substantial study that has been done to date that I know of on parenting plans, and that's the study that I mentioned that appears in the University of Michigan. They found some interesting things. They found that over half of the parenting plans address decision-making beyond the prescribed areas, beyond health, education, religion, residency. Parenting plans went beyond that and started talking about decision-making around such issues as child care, recreational activities, For those of you with teenagers, that all-important question of driver's licenses and cars, when they can get their freedom. They also found that only 16% of the clients chose court as the future dispute resolution forum. 58% chose mediators, 7% chose counselors. Of those people that chose a dispute resolution forum other than court, a full 30% went beyond that and designated who that should be it a specific mediator, a family member, a religious leader, tribal court. What did it do for residences? Looking at pre-parenting plan to post-parenting plan, the researchers saw the mother as the primary residence drop from 79% to 70%. The fathers as the primary residence drop from 18% to 10%. But a combined residence increase from 3% to 20%. And lastly, do parenting plans help parents focus on their children and reduce future conflict? The researchers went to you lawyers, interviewed a bunch of lawyers in Washington to determine that. 40% of the lawyers said no. Things stayed the same. Clients haven't changed. Language isn't going to change anything. We still have parents that are in as much conflict as ever. 60% said it helped. Said things are better, things are different. What they said was that the act of creating an individualized parenting plan provided an opportunity for parents to discuss the challenges of such issues as dividing parental responsibilities and tasks when both parents are working in a more equitable way, and addressing the particular needs of children, age group needs, teenagers that are reluctant at best to follow or want a structured access or parenting forum, and the needs of young children who might have a bit more of a problem with switching back and forth residences. I think the views that were expressed by lawyers in this survey are meaningful for two reasons. First of all, 40% said there was no change, 60% said there was improvement. The way I read that is 60% of the cases saw improvement, 40% didn't see anything worse happening. If we have an opportunity to improve the parenting lives of families in divorce situations in 60% of those families without doing harm to the other 40%, I like those odds. I think there's no downside. Secondly, in terms of the lawyers' views, I think that the 40%, whether they fell in the 40% or the 60% category, are probably reflective of the individual mindsets of the attorneys that were interviewed. If the attorneys come from an adversary or advocacy background, I suspect they didn't see any change in the law. If, however, they've come from a background that includes, as many of the law schools do now, conflict resolution theory, that include mental health and family dynamic theory, if not schools and the continuing legal education programs such as this, then I think they were more positive. In conclusion, are parenting plans a panacea, a cure-all? Of course not. I'd be a fool to stand here and tell you that they are. But I think there's something that we have to bear in mind. There'll always be the 5–10% of families that are dysfunctional that come into the system and are going to require hearings and decisions being made for them. There's always the 5 or 10 or 15% of families on the other end that no matter what you do, these families are going to get along. They're going to cooperate. They're at a level of functioning. But what about the silent majority, the cases that settle somewhere in the process for whatever reason, whether because they don't have the money to further litigate, whether it's through a negotiation process in which one thing is traded off for another. I think we need to establish a vehicle or a system that addresses the needs of the silent majority who are not receiving the individual attention being paid to post-divorce parenting. Will this change the art of lawyering and judging? Sure it will, without a doubt. I'm reminded of, lastly, I'm reminded of an exercise that Jay Folberg, the current dean of the School of Law at the University of San Francisco, he came to Connecticut 18 years ago, spoke to a group of judges, all judges of Connecticut, about an extremely radical and just out there idea called mediation. He asked them to cross their hands, put their fingers together. And I would ask you folks to do it. I know we're mental health people and we like the touchy-feely stuff. Which hand is on top? Right thumb or left thumb? Now cross your hands the other way. Put the other thumb on top. How uncomfortable change feels. It's just not right. It's not what I'm used to. It's not the way I've done things. Why, I don't know, but I've always done it this way. Eventually, this will feel comfortable. I think the time has come to look to the story that I told you earlier. I think we have an opportunity in our future to stop making losers out of winners. I thank you for inviting me, and thank you for your attention.
Well, thanks very much, and thanks especially for introducing us to some brand new ideas, which I'm sure are going to influence us a great deal from today on. The next speaker is also going to touch on a need for greater awareness of what we are doing in family law. I'm pleased to call upon Catherine Beamish to discuss with us the topic across cultural lines.
Thank you, Jim. I practice law in Sioux Lookout, Ontario, and I thought for those of you who are a little rusty on your geography, I'd tell you that Sioux Lookout is a little town in northwestern Ontario. There's less than 5,000 people there. It's about 1,300 miles northwest of here, and it costs me more to fly to Toronto than it costs you to fly to Europe. It's also the kind of place where the snow has already been on the ground for 2 weeks, and we expect it to be there for the next 6 months. I say that by way of introduction because when I was asked to speak about cross-cultural parenting disputes, I couldn't understand why I was being asked to speak about this topic. I thought, I don't know anything about this sort of thing. However, I do know something about working with Aboriginal children and Aboriginal families. I've worked extensively in the field for the last 20 years, and I thought that perhaps I could share some of those experiences with you in the hopes that not only will they be helpful to those of you who may have dealings with Aboriginal children and families, but for those of you who deal with families of other cultures, you may be able to extrapolate some of this for use in dealing with families of African, Canadian, Chinese, South Asian, and other cultural groups which are now an important component of the Canadian fabric. When I was asked to talk about parenting disputes, I immediately thought about custody disputes between mothers and fathers with respect to their own children. And when I thought about that in the context of my Aboriginal practice, I thought back over 15 years of family law practice and thought, I can hardly remember a hotly contested custody dispute involving an Aboriginal child within the family. I thought about what I have learned about the culture when I was seeking an answer for this. And I came up with these ideas, which I would like to share with you. Aboriginal people don't own their children. I think they have a fundamentally different view of children and the place of children in the family and the community. A child is seen as a gift from the Creator and is on loan to the parents, to the family, and to the community. This is a fundamental value that runs right through the culture, and I think that this may have a great deal to do with the fact that we don't see, even in Aboriginal people who are more acculturated to our mainstream society, we tend not to see hotly contested custody disputes between them. Collective responsibility for child rearing is deeply rooted in the culture. The practice of having children raised by somebody other than their natural parents also seems to be a fairly natural thing in the Aboriginal community. For example, in many Aboriginal communities, there's a strong tradition of giving the firstborn child to the grandparents so that they would have somebody to care for them during their old age. This is done quite frequently without any apparent effect on parental rights or on affection between parents and children. The parents remain the parents of the child, regardless of their role or lack of role in the actual day-to-day raising of the child. Similarly, in the Aboriginal community, the placement of siblings with different families within the communities seems to be an accepted practice. I think of a number of divorces I've done, because there are divorces, but the issue of custody is never a hotly contested issue. And I've done a number, I can't count how many divorces, with custody arrangements that go something like this. Custody of the child A to the mother, with care and control to the maternal grandmother. Custody of the child B, jointly to the mother and father, with care and control to the father. And custody of the child C to the mother, with care and control to Mrs. X. I don't know how the courts respond to that, but it seems to be the only way of using legal terminology to describe the family and child care arrangements that are predominant in many Aboriginal communities. The parenting disputes that I've seen involving Aboriginal children almost always occur when the dispute is between somebody outside the community and somebody from within the community. And that may on occasion be a parent who's seeking to take the child away from the community. And those efforts are often the situations in which one will see a contested custody dispute. It's sort of between the community and the person who's seeking to remove the child from the community. And even if they may be framed as an action between two parents, it may in fact be the community itself, which is seeking to keep the child, as opposed to the person or person who's attempting to remove the child from the community. That's about the only situation where we do see custody disputes that are contested among the Aboriginal community. The other place where we see parenting disputes in the Aboriginal community is in the child welfare system. The case law, the statutes, royal commissions, inquiries, books, writing about the subject of Aboriginal children all seem to focus on this system. And I think this is rooted in the history and the unique situation of Aboriginal people in this country. The residential school system was a vehicle which took Aboriginal children away from their homes and communities. Its effect on language and culture were devastating, and its effect on family life is still being felt to this day. The tremendous number of today's parents in the Aboriginal community who were never parented because they were removed from their families and communities at age 4 or 5 or 6 years old. And other than their parenting that they received from their parents or grandparents as early children, never had an experience of being parented. And this has had an untold effect on the social fabric of family life in the Aboriginal communities. Now, the end of the residential school system wasn't the end of the problem for Aboriginal families. The next major influence, which had a very significant effect on Aboriginal families, was the child welfare system. In Ontario and most of the country, the child welfare system didn't begin to impact on Aboriginal families until the mid-60s, when child welfare services were extended to Indian reserves in Ontario and across the country. What resulted from this extension of services was a phenomena which you may have heard of, known as the 60s scoop. The name's a bit misleading because although it started in the 60s, the practice of wholesale apprehension of large numbers of Indian children and placement outside of the community continued until the early 80s, and in some situations continues today. Phenomenal numbers of Aboriginal children were removed from their homes, placed in the homes of non-Aboriginal children, non-Aboriginal people, for the purposes of adoption, including significant numbers of Aboriginal children that were sent to essentially non-native middle-class homes in the United States. And you may have read in the papers over the years of some of the horror stories that have emerged in the cases of individual children who were victims of the 60 scoop. Basically, historically, it appears as though the 60 scoop was a mistake, and that although some individual children may have benefited, the destruction of family and community life in the Aboriginal community had untold effects. Today, Native children continue to be overrepresented in the child welfare system. By the 1980s, the early 1980s, the situation in the child protection system as it related to Aboriginal families was the subject of a number of inquiries. And the most graphic of those was an inquiry conducted in the province of Manitoba by His Honour Chief Judge Kimmelman of the Provincial Court Family Division. And in his report, he indicted the child welfare system and called it cultural genocide. And that's pretty strong language for a judicial review of that sort to use. But I think it reflected the situation as it existed across the country with respect to Aboriginal children in the child welfare system in the early 80s. As a result of that report, two major developments occurred. One of them was the change of legislation in Manitoba so that the definition of the best interests of a child included consideration of the child's cultural and linguistic heritage. And it's one of the first recognitions that we have of culture as an important component of best interests. The second principle, which emerged from Judge Kimmelman's review, is the development of Aboriginal involvement in all aspects of the child welfare system. In Ontario, the situation was not quite as dramatic as in Manitoba, but was still bad. The Aboriginal population was significantly overrepresented in the child welfare system. And the majority of the children in the system were in non-Aboriginal homes. Coincidentally, in the 1980s, in the early 1980s, Ontario was involved in a major revision of its Child and Family Services Act to replace the Child Welfare Act. And for the first time, the Aboriginal community was involved in the drafting of sections, and specific provisions with respect to the cultural treatment of Aboriginal children were included in that act. In the written material, I've outlined the provisions in full, but I'd just like to highlight a couple of important ones. The first one is in the statement of principles at the beginning of the act, where it indicates that Indian and Native people should be entitled to provide their own child and family services, and all services to Indian and Native children and families should be provided in a manner that recognizes their culture, heritage, traditions, and the concept of the extended family. Another significant provision in the Ontario CFSA, Child and Family Services Act, is what we call the special best interest test. And that is a section which is set out at various places in the Act, which provides that the determination of the best interests of an Aboriginal child, the Act uses Indian and Native. I'm using Aboriginal as probably a more current term to deal with all people of Aboriginal ancestry. Basically, it makes provision for a special best interests test for Aboriginal children, recognizing the uniqueness of their culture and the importance of cultural preservation. A third major provision in the CFSA was the giving of party status in child protection proceedings to the child's band, or as we now call them, First Nations. This was a really significant step in allowing the First Nation, the collective, the community, to have the same kind of rights in a child protection proceeding as a parent or child or the Children's Aid Society. And there are a number of other provisions, but those are, I think, the most important provisions. The emphasis on cultural sections with respect to Aboriginal children in the Act, in my view, means that the legislators intended that great weight be given to this factor. In fact, I was part of the joint Aboriginal Ministry of Community and Social Services drafting process, and that was, in fact, our intention. It was hoped that the placement of Aboriginal children in non-Aboriginal homes would be an exception rather than the rule, and that the historic wrongs would be righted through the use of the statute. I recently had the opportunity to preside over a director's review under the Child and Family Services Act. A director's review is a review of a placement decision made by a Children's Aid Society under the Child and Family Services Act after a wardship is ordered by the court. And the particular case, known as the case of TL, I understand it's recently been reported in one of the family law reporters. And I, in my decision, dealt with the weight to be given to those native sections and expressed the view that they should be given great weight. And in fact, in that case, the Children's Aid Society had failed to, in my opinion, give them sufficient weight. The statutory provisions are quite strong, and I think that they have not been utilized to their fullest by social workers, by lawyers, and by judges. In addition to the changes in the child welfare law in Ontario with the development of the Child and Family Services Act, Ontario also saw the development of Aboriginal Children's Aid Societies, and Tikanagan Child and Family Services in Sioux Lookout is one of those agencies. The majority of them have assumed a full Children's Aid Society mandate under the provincial statute and are delivering all of the services that a Children's Aid Society normally delivers to families. Some of them have chosen to accept the lesser mandate and are delivering only the softer or preventive services to the Aboriginal families. Aboriginal agencies tend to have a different, more holistic view of the situation of children and families, and they tend to treat the whole family as opposed to focusing exclusively on the child. The plan of such agencies is generally the reuniting of the children and the parents if and when the parent situation improves. Termination of parental rights is something that is foreign to the culture and is avoided if any possible alternative can be found. And the practice of adoption, legal adoption, involving the termination of parental rights and the creation of another parent-child relationship is just not understood and unheard of in the Aboriginal community. I should point out some Aboriginal culture doesn't exist in a pure form, and there may be some Aboriginal parents who are taking advantage of legal mechanisms to protect their interests. And I see quite a number of Aboriginal people who are caring for children under customary arrangements who are now afraid that those customary arrangements will not be respected by a parent, and who come seeking the protection of an adoption order so that the natural parent can't come galloping in after 12 years and saying, "Thank you for doing such a nice job with my child. I'll take her now." And which wouldn't have happened culturally in a pure situation, but some people are afraid now with urbanization and acculturation that the traditional cultural arrangements may not be able to exist of their own and are seeking legal protection. But with that exception, adoption is not a big item in the Aboriginal communities. The culture of Aboriginal people is still based on the relationship of the people to the land and their sense of personal interrelatedness in the community. In spite of the fact that an Aboriginal kid on Yonge Street may be wearing an AC/DC t-shirt and may appear, for all intents and purposes, to live the same lifestyle as any other teenager on the streets of Toronto, I think that the assimilation, even of Aboriginal people in Toronto, is really still very superficial, and that the cultural ties and the cultural values of the traditional community are still very strong in Aboriginal families. It seems that our culture has sort of lost some of those values, that we're not as connected to the family, to the community, and certainly not to the land as the Aboriginal culture is. And that across the board, the institutions, the processes, the courts of our society reflect our culture. And the problem, of course, is that the rules of our culture are often tremendously inappropriate for a culture which is exceptionally different from ours. One of the important things is that Aboriginal cultures haven't gone through this distancing process, and the culture is still very much a part of each individual. And you know that culture is part of each of our identity. In the case of an Aboriginal child, culture is not just a small component of his identity. His culture may be most, or at least fundamental, to his identity. And when culture is such a strong component of identity, an in-depth awareness of that culture is necessary in order to intervene in any way in a family unit. And obviously, persons who share the child's cultural identity will best be able to understand and intervene with respect to that child, and those who don't share the culture will have difficulty. Consequently, our law and our social sciences have not dealt well with the significance of culture for Aboriginal people. And as a result of their recent inclusion in the global village, Aboriginal cultures are in a state of transition. I've alluded to this a couple of times already. It's my submission that during this time of transition, traditional culture remains fundamentally important. This was noted by Justice Sissons. I don't know if you're familiar with Justice Sissons. Was one of the first judges of the Northwest Territories Court, traveled on circuit and wrote and made many creative decisions among the Inuit. And his observation was that even customs which he considered to be surprising, such as the adoption by Inuit grandparents of their grandchildren to keep them company, served a fundamental purpose, and that for a society in transition, those cultures needed to be maintained to allow the people to to negotiate the cultural transition. Another crucial issue that comes into play in dealing with the issues of culture in Aboriginal children is the issue of culture versus bonding. Many of the cases involving the placement of Aboriginal children in non-Aboriginal homes come down to this issue. And the leading case is a case in the Supreme Court of Canada in 1983 called Racine and Woods. The child, LW, was taken into the care of Manitoba Child Welfare Authorities when she was 6 weeks old and remained in care for about 2 years. She was then returned to her mother, but her mother was still having some difficulties, and the mother voluntarily returned her to the former foster parents who were non-native. And she remained with them for a further 4 years. And when the child was about 6, the mother sought a return of her child, and the case made its way through the court to the Supreme Court. The Supreme Court felt that the best interests of the child, the significance of cultural background and heritage as opposed to bonding, abates over time. The closer the bond with the prospective adoptive parents, the less important the racial element becomes. This trend has been followed almost exclusively in Canadian jurisprudence. I followed it in my case involving the Director's Review, TL, that I mentioned to. The British Columbia Appeal recently followed the same logic in the case of David Tiro, which you may have read about, the nearly 2-year-old toddler who was allowed to remain with his non-native adoptive parents as opposed to being returned to his native biological mother. The problem that we have with this, and I'll use the example of the Racine and Woods case. I talked to the aunt of that child. The child is now 17 years of age, and I asked her what happened after the Supreme Court made the ruling. And she said that the adoption had broken down by the time the child was 13. The child had been on the streets of Winnipeg and Toronto. She'd been in a succession of institutions and foster homes. She'd just been released from the Manitoba Youth Detention Center after serving a custodial disposition for offenses involving taking an elderly couple hostage at gunpoint. She had finally found her natural mother, but by the time they were reunited, the child was too disturbed and too angry. The relationship between the mother and child was gone. And this is the pattern that we see over and over and over again. Those of us working in the field are aware of the fact that the success rate of these cross-cultural placements of Aboriginal children, particularly during adolescence, is dismal. Unfortunately, we don't have good research to support that finding. It comes from the clinical experience of social workers, mental health professionals, Aboriginal communities. Everybody in the field knows this to be in fact true, but there's no evidence that can be presented other than it appears that these placements don't work. Dr. Claire Brandt is a Mohawk psychiatrist, and he too has observed this in his clinical practice, this phenomena of failed cross-cultural placements. And he indicates that his records aren't sufficiently complete to do an analysis of why such cross-cultural placements don't work. But he does venture five hypotheses. And they deal with the bonding, the interruption of bonding and the abuse and neglect of the child prior to coming into care. But they also deal primarily with the fact that the non-native adopting parents or caregivers are not dealing appropriately with the child's cultural development. They're denying it, they're belittling it, they're failing to expose the child to that culture. And those factors also come into play in worsening this adolescent identity crisis that all children experience, but that appears to be particularly acute in the case of Aboriginal children in non-Aboriginal homes. My time is almost up, so I will try and pull together some of my rambling thoughts and leave you with a few things to think about. What does all this mean for Aboriginal children? What does it mean for other children? I think we can make the following observations. The provisions of the Child and Family Services Act, with its focus on the preservation of cultural identity for Aboriginal children, is a good thing. And perhaps we ought to be looking at similar types of provisions or similar types of concerns when we're dealing with other circumstances involving Aboriginal children, including custody disputes. Maybe we should also be looking at this sort of thing with respect to other children of other cultures and the importance of preserving their cultural identity in custody as well as in child welfare. Understanding of cultural background is fundamentally important for all of us. The Aboriginal culture, fundamentally different from our own. Their worldview, their attitudes, everything is just not like ours. And I think we need to be extremely conscious of that in any dealings or any intervention with Aboriginal children and families. We also have to remember the importance of culture, the significance of culture at adolescence and the formation of the healthy identities of Aboriginal young people, and the fact that for cultures in transition, they need to rely on the traditions of their culture in order to successfully go through the transitional phase. It may be, for some children, that the cultural needs can be met by heritage language classes and participation in cultural events. But for Aboriginal children, and I would venture to say for children of many other cultures, culture is too significant to be confined to activities on Saturday or for an hour after school. It's part of their entire well-being, and that factor has to be taken into consideration in dealing with issues of culture. And the question, I guess, is can we extrapolate from my observations and the experience of Aboriginal children to other cultures? And I think we can. Last week I was at a conference on youth justice and crisis, and I heard Dr. Ralph Agard, past president of the Metro Toronto Children's Aid Society, talking about the situation of African and Canadian youth. And he indicated to me, and I was shocked by the statistic, that 25% of the children in care of Metro Toronto CAS are black children. And I would venture to guess that the majority of those black kids are not in black homes. He also talked about the lack of sensitivity to black culture by social workers, by judges, by lawyers, about the importance of preserving the cultural identity of black youth, the fact that black families are also in a state of transition and needing to retain their culture. And I became convinced that the experience of Aboriginal children and our Aboriginal families in this country is not unique, but that in fact many of these factors could be extrapolated to those of children of other cultures. Thank you.
Thank you, Catherine. We're now having a coffee break, and again, I'd ask you to return in 15 minutes if you possibly can for our symposium of the 5 judges. Thank you.